Hello, everyone. Thank you so much for joining us today. Um, I'd like to introduce to you the panelists that we have. My name is Elizabeth Long. I'm an immigration lawyer based in Canada at the law firm of Long Mangoji. And Zia Sumar, as well, is another lawyer who works with a lot of our corporate clients. And she's here with me as well, presenting on the Canadian immigration side. And with us, we have our friends from Pearl Cohen. From the US side, we have Ari Farkas, who is a partner at Pearl Cohen, and Rebecca Linetsky, who's another lawyer at Pearl Cohen. And they're going to be presenting from the US immigration side. All right, so let's start talking about the Canadian side. So since the COVID-19 pandemic happened, Canada has instituted two main travel bans. The first one is that it relates to air travelers, people who are flying into Canada, and really, according to our geography, the only people who don't fly into Canada are really people coming from the States. So anybody who is outside of Canada and the US, the airline officers, they're not the airline officials, they're not going to allow you to board flights to Canada unless you fall into one of the exceptions. So in terms of workers, which we're really concentrating on talking about today, if you have a work permit or a work permit approval, they will let you on the plane. And the people who have immediate family who are Canadians or permanent residents in Canada. So those people are the people who can come to Canada, okay? Now, the family members of those who are residing in Canada on a temporary basis, they can't just get on the plane, but they can ask for an exemption from the normal rules. So you'll get a letter and you ask immigration for that, okay? The essential workers are workers. Sometimes we have workers who may be exempt from a work permit to come to Canada, and but they can still work. We may be able to ask for exemptions from those. So these, the last two are people who we are asking for a special letter from them to be able to, from immigration, to be able to board the plane to come to Canada. But just because you're able to board the plane, it doesn't necessarily mean that you're still going to be allowed to be in Canada. So sometimes we have people who get to the airport in Toronto, and still the officers reject them from entering Canada, because you also have to show that even if you fall under one of the exemptions, that you're going to be in Canada, your stay in Canada is on a non-optional and non-discretionary purpose. For example, if you had a worker who is only going to need to be in Canada and they can work in Canada on a remote basis, the officer might say, well, you don't necessarily need to be in Canada. You can work from home in your home country on a remote basis. I don't think you need to be in Canada at this point, and you don't pass that test, okay? So even if they are able to board the plane because they fall under one of the exceptions, it is so important to explain to the officer why it is that they physically need to be in Canada as well. So the second travel ban we have is with the US. So people who are coming from the US, they can fly to the border, or they can drive to the border, and they can make their applications to enter Canada. But we still have another test for them, in that they can only come to Canada if they're coming for an essential purpose. So what are some of those essential purposes? People who are coming to Canada to work, okay, they can make their applications for the work permits, as long as they can show that that work does not need to be done, cannot be done remotely, we can apply for the work permits and they can come to Canada. People who are coming to study, family reunification, and there are other things. For example, they're providing critical infrastructure support, healthcare, etc. They're coming to Canada to land. These can be for essential purposes, and then they can actually come to Canada and enter Canada. So this is for workers really coming to Canada. People who are in Canada, it used to be that we can sometimes send them to the border and go around the flag and do what we call is a flag polling. They make a U-turn around the flag at the US and come back and apply for the work permits. They are not allowing people to do that at the present time. The flag polling is not an essential purpose. So that figures into a lot of our plans as to how someone might be able to get their work permit and where someone can apply for the work permits. Currently, because of the pandemic, there are certain effects on processing at the visa posts or at the immigration centers. All applications now are submitted for the most part online, okay? And the processing officer is still working. Oftentimes the officers may be working from home, but they're still processing the applications. However, we are seeing at a lot of visa posts that the work permits are being processed only for those that they deem of a critical nature. So it could be that many of the work permits, especially where you can show that the worker is not necessarily of a critical nature, that they may take a very long time in processing the application. The biometric centers are closed right now within Canada and other areas. So for most applicants who are applying for the work permits, they may not, unless they've applied for a visa or work permit, study permit in the very recent, I'm talking about maybe late last year or very recent past, they may not have done their biometrics yet. And now everyone who is applying are supposed to get their biometrics. So if the center is closed, then their application may be on hold. Now, yesterday, we had a very strange occurrence where there was an announcement made by the government, put on the government website that said that temporary residents in Canada, workers, study permits, and visitor holders in Canada who are applying for extensions don't need to do biometrics. But then all of a sudden, a little short while later, in the same day, it was taken away. So we're not sure whether or not this actually means that the people are biometrics inside Canada or people biometrics exempt or not. Right now, because it's taken off the website, we're assuming that that's not the case. Stay tuned, though it could be the case soon. A lot of places, it depends on which area. The visa application centers may be closed for certain areas in the world, or they may be open. That also means that the biometrics and passport submissions, etc., may be an issue. Okay. There also has been new COVID policies for workers inside Canada. And in fact, we've just had some very exciting policies that were just announced a few hours ago yesterday. So first of all, this policy was announced a while ago. Workers who have work permits in Canada and they're applying for a different position in Canada, normally what happens is you can't work in that new position until you have the work permit approved. But if you now are in that situation, and the reason why they're doing this is because a lot of people don't have their biometrics and therefore their work permits are just going to be on hold for months on end, okay? What they are saying now is if this is the case, you can actually apply for an interim approval. It's not a work permit, but they will allow you to work in that new position while you're waiting for the new work permit. yesterday, this is the exciting announcement. Yesterday, the workers who are in, they announced workers who are in restoration period after January 30th. So if you had status until January 30th, but then afterwards you lost the status. For example, your work permit application was rejected because you didn't have an LMIA, and now you have an LMIA and you're applying again for the work permit. However, it's going to take a long time because you don't have biometrics and there's no way for you to get biometrics. What are you going to do? First of all, you have until December of 31st. Normally you have 90 days to file restoration. Now they have allowed you until December 31st to file your restoration application. And if you are in the restoration period in this length of time, so you had status until January 30th, and you filed a restoration before December 31st, and you were a worker before, and you have an employer, you're applying for employer-specific work permit, not open work permits, but LMI work permits or IMP work permits, you can actually apply for permission to work while waiting for your restoration application to be decided. This is very new because before, if you were within the restoration period, you lost your status, and then you are applying to restore your status, that period you weren't allowed to work. Now they are allowing you to ask for special permission to work during this period of time. Finally, international students who normally can only work part-time during their studies, they can now work full-time in essential work while studying as well. So those are some nice policies that the government has recently put into place to allow workers to work, recognizing the difficulties in getting work permits approved without biometrics right now. There's also an isolation period as well, in that when anyone comes to Canada, irregardless of your immigration status, you are supposed to have a mandatory 14-day isolation period, okay? The only people who are exempt are people who are coming to Canada to work under essential work. And it can't just be you decide that you are essential work. It's actually it meets that definition that the CBSA border officer says, oh, you can come into Canada. It's actually even more, it's another level that has been found by public health to be at that level of essential work that you can actually be exempt from the isolation period. Oftentimes this is, people who are maintaining specialized infrastructure that is essential to the Canadian public, okay? If you do not comply, if you're not under the exemption and you do not comply with the 14-day isolation period, the penalties are very harsh. It can be fined up to $750,000, 6 months in jail, and the worker will become inadmissible. So really, really make sure that your employees adhere to this. In fact, what we normally do is we provide the immigration officer with a set out quarantine plan. Where is this person going to stay? How is he going to get there? How is he going to get food and other essentials to him while he's in isolation period? So I just like to sort of end with a few things to keep in mind when you're applying during COVID times. First of all, the processing time is going to vary. We're no longer processing things under normal times. So make sure that you have that discussion with your lawyer beforehand. And if you're thinking, oh, I might want to bring someone over, even down 6 months, 7 months down the road, have that conversation with your lawyer now, because a lot of these processing times are changing, and the processes and how someone applies is very different. We can't just have someone come and fly into Canada unless they're coming from the States to apply at the port of entry anymore. that is really important for people who are used to transferring employees to come to Canada who are visa exempt. Before, you can just fly into Pearson Airport or drive to, or fly, fly in from, anywhere. And if they're, for example, from the UK, they can just apply for their work permit at the border. They can't even get on the plane right now. So it does require some figuring out as to how to apply for these applicants as well. No flagpolling. So this is a big problem that immigration still has not come up with a solution yet. We do have people who are in Canada, and they may even have work permit approvals from the visa post. The first work permit normally can only apply outside of Canada. And normally what happens is we would send you to the border and you would get the work permit at the border. We can't do that anymore. So some of the tactics have been, we apply for a second work permit inside Canada, because then the law allows you to apply for the second work permit if you have the work permit approval, but you don't have the work permit in hand, to apply for another work permit in Canada, or you may need to leave Canada and come back. Although sometimes, the flights going back and forth may be a nightmare as well. Even if you have a work permit approval, again, it's not a guarantee that even if your work permit is approved, the worker would be allowed to come in, especially if all the work is done remotely. So that has to come into some of the thoughts process as to whether or not and when someone can come into Canada as well. Okay. Finally, if you are thinking, oh, finally, a worker has come into Canada, our employees coming into Canada, and they can now start working. Well, actually, no, you have to keep in mind the isolation period, 14 days isolation period. They might be able to work remotely, but they can't physically go to the work site until after the 14-day isolation period. Preparing beyond COVID. I just have two things to say about this. First of all, you're going to hear from our friends at Pearl Cohen about some of the policies in the States, and it may not all be good news as well. Thinking forward as to how government policies work, we're going to have a lot of unemployed people in Canada, in the States, and I think it's realistic to think that oftentimes these governments will look to tightening some of the rules on allowing foreign workers to get work permits. If their own nationals have a high unemployment rate. Oftentimes what we're doing right now is we are planning with companies in the States to transfer their employees to Canada. We have a lot of very good work permit policies that allow workers to come to Canada to do so. So far, as you can see from the policies that I've outlined, the Canadian government really does recognize that we need workers to work in Canada to sustain the economy. And so far, our policies for the work permits are still very, very good. We have intra-company transferees, which are very much like the L visas, where you're transferring your senior management and specialized workers to a related company in Canada. We have global talent streams. So these are for IT workers and, for people who are new employees, but you want to hire them to come to Canada. Free trade agreements. We have agreements with the States, Mexico, Australia, EU, Colombia, Peru, and the list goes on. And a lot of professionals who fall under the agreements, we can get them work permits in Canada. We have Francophone work permits. So if you have employees who speak French and you offer them a high-skilled job offer, they can come to Canada to get their work permits. Different provincial nominee programs, we may be able to get them work permits. And the list goes on. I've just stated some of the ones I like for the work permits. So think about long-term wise, if you want to keep your employees working for your business, whether or not you want to then think about maybe transferring them to Canada as well. And for those employees who are in Canada, think about getting them to submit their permanent residence applications now. There was a really significant lowering of express entry points before last week, because they were only inviting people who had Canadian experience, and a lot of people didn't have their English exams done. So it went down, I think it was 430s. And then it jumped up last week to 478 because of the fact that they started inviting people from outside of Canada again. But it could be that the points are still going to go a little bit lower because of the fact that a lot of people wouldn't be able to have their IELTS done, their English exams done, or their education credentials assessed yet. And so, you know, this period of time, if they do have all of those tests done, it's a good time to submit their application. Also, you know, there's expansions of certain programs like the in-demand occupations for the Ontario programs. So it's a good time to submit the applications, and you never know. In immigration, I usually advise my clients in that if you want to apply while you can, because the immigration laws changed like that. And it could be that you miss an opportunity and you can't really go back anymore. Okay, so this is our information. We'll be sending out a video recording of this session and the slides for this session. And if you have any questions, please do contact us and let us know you've been to the seminar. We do offer discounted consultation rates for those people who've come to our seminars. We also have a COVID-19 update page in case you want to check it out, because laws are changing so much that the information changes constantly. And so we do have an update page there as well. Okay. So that's me. Ari and Rebecca, are you guys ready to present on the US side?
Well, certainly. Elizabeth, thank you very much, firstly, for this opportunity to speak up in Canada, even though I can't come visit now. Hold on one second. Let me just get this teed up. Okay.
Wonderful.
All right, so good afternoon, everybody. Today, as we already heard from Elizabeth, the effects of COVID-19 and government policies upon immigration into Canada. And so now we're going to focus on the effect of immigration into the United States. And so in doing though, we're going to structure this slightly differently. We're going to start with a local focus just between US and Canada, then one step back to see how it affects the greater immigration or the greater travel between other countries in the United States. And lastly, we're going to look at one step even farther back, rather, the presidential proclamations that have affected immigration as a whole, and then one step even farther back to see how things are going today in USCIS and the processing of applications that exist. I will correct one thing I learned just from Elizabeth now about entering Canada. So we have a little notation that I'll correct in our slides about traveling to Canada. So thank you for that. I've learned something just for the past 20 minutes I did not know. There we go. So clearly it's affected all travel cross-border. No one can deny the effects of COVID-19 and government policy changes effects on both immigration for the business world primarily, but also just in the individual world as well. Let's skip that part. So essentially right now we're experiencing between the US and Canada was the agreement between the two countries to limit to essential travel only. This is set to expire on July 21st. I am pretty confident that it will be extended beyond that date. However,
August 21st, I think.
August 21st, there we go. And possibly even beyond that date as well. Things are very much up in the air. But the key aspects of this, besides the definition of what is essential travel, which we don't have as much clarity as to what is essential. We have the clarity only to what is not essential. What is not essential clearly is tourism, recreational travel. But we've received a lot of very inconsistent reports when people try to cross the border to enter the United States from Canada, where they have a letter from their employer saying that this person is essential, and been told by a CBP, that's very nice, but you're not essential. They feel for the greater U.S. government, you're not essential. So what we certainly know is essential is things dealing with medical, whether it's directly or slightly indirectly related to COVID-19, whether it could be support staff or research, or doctors coming in to assist or nurses coming to assist. We know that primary or important industry is considered essential, like shipping between bringing in medical supplies or food supplies to the United States. But these restrictions are limited to only the ports of entry, land borders, crossings, which means that if there's ever a question, this is our view on it, is that if there's ever a question of whether or not you're essential, we can just kind of skip the entire question by flying into the United States directly, as opposed to trying to enter a land border. Maybe slightly more expensive, but it does obviate any need to really deal with this question of essential versus non-essential. And that's what we found is sometimes the most practical way of dealing with things is just by saying, maybe it's not, I don't have to deal with it in this manner. We'll just skip it, essentially. This does apply, just to be clear, it applies to Canadian citizens and other foreign nationals living in Canada. So it's really anyone who are trying to enter at a land border in Canada. However, I just do want to point out that CBP, Customs Border Protection, is still processing TN visas. And this is where some of the reports have come from, where a Canadian national will come, present their documentation, be told, congratulations, you've got a TN visa to come in as a economist or a management consultant. We'll talk about that a little later. And then when they try to enter the United States, say, well, whoa, you can't enter, you're not essential. So they're still adjudicating the applications, but it doesn't mean that you're going to get into the country. And so again, that's where that this plan or directive of have your TN adjudicated at the best possible location, which may be a border crossing rather than an airport, but then enter the US via air travel. Now take this a little further back. So that's only with dealing with Canada, but how do we deal with other countries? Which other countries have current travel bans or restrictions? So the first one was China. That was back in January, and it was expanded to first include Europe, or Schengen as it's referred to, those 27 countries that have created a block for travel without use of visa or identity cards. Then it was expanded further to include the UK, Iran, Brazil. There are rumors that we'll see a few more countries being added from South America in the future, but those are rumors. So we're not going to list the names of those countries right now. But if you're traveling from one of those countries into the United States, if you're not a US citizen or meet certain exceptions, then you're restricted in your ability to enter the United States. It applies to all foreign nationals, even transiting through this. It became a big question that we dealt with for a client recently, where they were trying to figure out how to get them into the United States. And we couldn't even transit them through any European airports because they would hit those same restrictions. And as Elizabeth mentioned, it's the airlines that are kind of tasked with deciding who gets in, who doesn't get in. And it places a great burden upon the airlines because they don't always have clarity. Remember earlier in this current administration, there was a ban against a number of countries, people coming in from a number of countries. The airlines didn't know how to deal with it, and so they just shut everything down until they get clarity, because they receive a fine for letting someone through. And so in order to minimize it, their lawyers couldn't get clarity. The US government wasn't giving clarity. And so the same thing really applies here, is that whenever there's a doubt, you're going to be blocked, even if you believe that you're in concert with the law. Now, there is a way to come in, though, and this is where I might have to admit my correction here, is that if you want to enter the United States, you can transit through a third country not included in this current restriction. However, you have to be there for 14 days, self-quarantine, and then you can enter the US. And we said Canada, but it would seem that Canada is not an option for most people to enter. So I personally would suggest if there's someone to get to Barbados or go somewhere with a beautiful beach, that's my always my suggestion, if possible, for 14 days. But again, it all depends on the specifics of of what's going on in those countries, and do you want to put yourself at risk, and also comfort, depending on where you're going, if you'll be comfortable in that location. Now, there are certain exceptions we mentioned to this. That means U.S. citizens and immediate family members can enter the United States traveling directly from those countries, U.S. green card holders and immediate family members, and essential or national interest workers. So that's usually defined as people who are related to the research or treatment of people with COVID-19. Okay. The next level of this is the Presidential Proclamations of 2020. So the first Presidential Proclamation dated to April of 2020, and that essentially said, that essentially said that they were no longer allowing people who were waiting to be granted a green card immigrant visa to enter the United States. This essentially, this essentially did nothing because the consulates were already closed. And it stated that if you had not been granted the visa in time, then you weren't able to get a visa to come to the United States and enter the United States. This was extended by the next proclamation. And by the way, just an aside, it also affects Canadians who are seeking permanent residency through consular processing, whether in Canada or abroad. It really doesn't make a difference. Whether it was in Canada, it could be in France, it could be in England. All the US consulates around the world are essentially closed at this point. And so despite the Presidential Proclamation, the reality on the ground also prevents you from getting it. So there really isn't much in the way of let's call it a bite to that bark of the proclamation. In June, another proclamation was put out. First thing it did was extended the initial April 2020 proclamation until the end date, which is December 31 of 2020. So it extended this previous proclamation through 2020, the end of 2020. It also restricts the issuance of visas specifically for 3 specific types of classes of visa. The H-1B, which everyone knows is the visa for those people who are coming to the US to provide work in a specialty occupation. It means usually someone who's coming to do a job that can only be done by someone with a degree, at least a bachelor's degree. So engineers, accountants, lawyers, and so on. The L1 visa, the intercompany transfer visa, like Elizabeth mentioned earlier, and certain versions of the J1. So the J1 is the International Cultural Exchange Program of the Department of State. The specific categories that it restricted was au pairs, teachers, and the like. It didn't restrict doctors from coming in. It doesn't restrict post-grad students, researchers. And so there are certain J1 categories that are still unrestricted, but these are. But again, and here's the kind of the comedy of it, is that there are no consulates that are open. So whether or not the Presidential Proclamation was put in place, you're not getting an H-1B or an L1 or a J1. And also, there are exceptions to this, the same exceptions that were in the April 2020, which stated that if you're coming to the US for the purpose of treating COVID-19 patients, you can be issued that. And those are being issued by the consulates. Just recently, we had a doctor make an application for a visa pursuant to an H-1B to come to work in a specific ward that does cancer and COVID-19 patients. And she'll be issued that visa within a week. So again, this proclamation is, somewhat effective, but it really has no real effect if the consulates won't even accept your application or even entertain having an interview. Now, just a few days after this proclamation, CBP tweeted, I guess that's the way we get our information from the government these days, they tweeted that Canadian citizens are exempt from this. Not completely exempt, but they are exempt because they do not need a visa to be issued to them, right? Canadians enter the United States, we refer to as a Canadian B, but if they are, if they've received an H-1B or an L, all they need is the approval notice. They don't need to have a visa issued at the consulate. And so therefore, they are not affected. They get their J's, they get their H-1B or their L approval notice from within the United States, and they can just go to the border. Rather, take that back, go to an airport. Don't go to the border. Go to an airport, get on a plane, come to the United States, because going to the border will require you to prove your essential to the fight against COVID-19 or national interest. However, there are, just as an aside, there are certain categories where the consular closures will affect Canadians. One example is the E2 visa. So the E2 visa has to be issued by a consulate. That's not something that you can just use your approval from USCIS, because it's based upon a treaty between the US and another country, and so therefore it has to go there. Also, if you're getting an immigrant visa, right? So let's say you have, and we represent a number of people who are applying for green cards for spouses, where the spouse is in, well, that would work, but maybe the parent, the immediate relative, or a more distant relative from a foreign country, from Canada, they also need to go to the consulate or get that visa to come in. That Canadian waiver doesn't apply to immigrant visas. So, as we stated before, most visa categories can enter using the I-797 approval notice, and therefore these proclamations have no real effect upon Canadians unless it's one of those categories that require going to the consulate. Premium processing, which for a while was not available, was resumed on June 22nd for all applications. So now we're back to a situation where within 15 days, if an employer in the US wanted to bring over a Canadian citizen, in theory, within 15 days, by paying additional fee, they would have that I-797 approval notice in hand, and they could have that H-1B, that L, that O employee in the US. Essentially, none of the visa categories have been affected by the presidential proclamations. There are specific ones that weren't even mentioned. The O visa, for example, wasn't even included in any of the proclamations. Now, just to discuss a couple of other issues that we're having USCIS regarding delays, there was a recent report that USCIS decided to take in-house the production of green cards and employment authorization documents, which is a fantastic idea, and has led to a backlog of roughly 125,000 of these cards to be issued. With regard to green cards, it's not that bad because there are other proofs that you can use to show that you're in status, but with an EAD, employment authorization document, we really have a serious problem, because without that card in hand, you cannot work. You cannot get your work authorization. They will not allow you to work, subject to the I-9 rules. And so, with the green card, it's problematic. More people are more concerned about it, but the reality is the EAD creates a much bigger problem. And the other part of it is that the EAD is usually issued in the case of a intending immigrant with an advanced parole approval on the bottom. It says this card serves both as your EAD and your advanced parole. This stops people from traveling if the card's not issued. And if the card is issued late, then it may actually affect their ability to travel by shortening the actual time they have that card in hand, and therefore their ability to travel outside the US. There are reports of furloughs coming. According to, I forget which paper it was, USCIS is seeking a $2 billion bailout because there are fewer applications. And the reports say as much as 70% of the workforce may be furloughed as of August 1, which could further delay what we already saw, which was, people working from home, people working part-time, shifted working, and now with furloughs, we really don't know how that's going to play out, or which groups will be furloughed, who's going to be given a higher priority. There are also a lot of contractors who run the mailrooms. We're not sure how that's going to play out as well. Does that deal with contractors? And also with regard to just local offices, so most biometrics offices are scheduled to open on Monday again. Some USCIS offices have opened, and some have opened and then closed, and some of them have yet to open. So it's a matter of each office, based upon what's going on locally, really define, whether or not there's even availability. But as of right now, biometrics opening on Monday is a hope. I hope it will happen. We have a lot of clients who are waiting for the biometrics. In some cases, the biometrics really creates a hold on a lot of other steps in the process. And for some, it's just something that has to be done before they leave the country. And it's really causing delays on that side as well, like re-entry permits. So just a quick overview of the visa options for Canadian workers. Clearly, the B1 visitor's visa, again, we call this the Canadian B visa. It's a very unique visa because most people have to get a visa placed in their passport. If you're from one of, I think, 30 countries, there's a visa waiver program, but Canadians don't need either. They come in with an automatic visa, and it allows them to, as if they came in under with having that visa in place. So they can come in for 6 months, the full 180 days, unlike a visa waiver, which is only 90 days. They can extend that if they choose to. They can leave and come back, and it restarts that 6-month period. If they come in for the purposes of business visitor, it allows them to do anything that any B1 holder can do. So that's business meetings, negotiating contracts, attending trade shows, setting up new enterprises, overseeing the investments. However, you cannot perform services in the US, and that's a kind of a gray area. I always point to the famous case where a tailor would come from, I think it was Singapore or Hong Kong, and he would set up shop in a hotel room and take measurements. And USCIS said that that was working, providing services, and the US government said it's not. He's providing services back to his parent company, who then can do the work there and then ship the goods over to the United States. And so that's our bright line test usually, is where the services and to whom are they being provided. Now, Canadians under the NAFTA 2.0, I guess NAFTA, now NAFTA 2.0, the MCA, allows for additional things that they can do. Research and design, growth manufacturing, marketing, sales, distribution, after-sales services. All these things can be done. Most of them, though, again, are focused on work to be done for their companies abroad. It's not that they can come to the US to provide services in the US for US companies, but let's say, for example, an after-sales installation repair, they're really providing the services. Although the work is being done for the ultimate purchaser, the service is being provided to its parent company. Think of it that way, right? They're providing the service for the parent company, who is responsible for installing the equipment. And that's how you have to kind of look at it, shift it, the perspective. You're not looking at who's receiving the service, but rather who's it being done on behalf of, to give you an idea. To take it one step farther is, if you needed someone to come to the US who will be providing you services not in those categories, in a specialty occupation such as a lawyer. So a lawyer coming to the US to negotiate a contract on behalf of somebody else, they would actually require what's called a B1 in lieu of an H1B. So essentially, a lawyer coming to the US can perform productive work. They can be employed by they cannot be employed by a US company. They have to continue receiving their compensation from the foreign entity. The key here is that, unlike a regular H-1B, where you're working for the foreign entity, for the domestic entity, I apologize, the US company, here you're doing the exact same services, but the purpose of it is you're providing it to that foreign company. It's kind of an extension of what I was mentioning before. So again, think of the lawyer coming to the US for the purposes of negotiating or doing legal work for the foreign company, the Canadian company. And they're doing it in the United States while president of the United States. So some of the requirements here is must show that they meet the requirements for special occupation. So I was using the lawyer. Again, that's usually someone with a bachelor's degree, someone who that area of knowledge is being applied for that specific purpose. So for example, we would say an engineer, an accountant, a lawyer. These are like the prototypes, the archetypes of this type of visa. However, the issue that we have now is that the US consulate is closed, and a B1 in lieu of an H1B would not work with a Canadian B. You would need to go to a consulate to seek that visa. So if you're providing professional services outside of the allowances of the MCA, you would need to go to a consulate. It's a great visa, but right now the door is closed on that because of this restriction. The consulates are closed. Okay. There is the TN visa. The TN visa, again, this is a employment visa for Canadians in the United States. So now, unlike the H1B, the B1 in lieu of an H1B, unlike the Canadian B or the expanded NAFTA rules for B1s, the TN visa is specific to 36 limited professional categories. Amongst them are technical writers, high school teachers, lawyers, accountants, and so on and so forth. It's available both to Canadians and Mexicans. However, Canada, it's available for processing at the border, like we mentioned earlier, while Mexican citizens need to go to a consulate in order to get the visa issued. The employee must possess necessary credentials. So some of them, for example, like a nurse. A nurse requires licensure in Canada. They must have a degree, and they must show that they've applied for license in the United States and gone through a specific registration process. A lawyer just has to show that they are admitted in Canada. They don't have to be admitted in the United States. So each of these specific professional categories has its own necessary credentials that have to be checked. Some of them, for example, I think an interior designer only requires 2 years of experience and a degree of some sort, not necessarily a bachelor's degree. So, you know, it varies by type of employee and type of profession. And again, it's employment by a US company. So this is really the shift, right? This is where you will be coming in. We've done a number of accountants who are coming to work for large accounting firms. They did their schooling either in the US or in Canada, and then came to the US as full employees. The L1 intercompany transfer is another visa type. This allows for either full-time or intermittent employment. So this is just a word on intermittent employment, in that it allows you come to the United States to not for the purpose of being there full-time. We suggest this to CEOs sometimes who spend a large amount of time in the United States to get this, so that way they can always enter without having to worry about what they can or cannot do, right? Working our way backwards through the visa types, all those visa types have some restrictions, but a full employment visa has no restriction on what you can do in the US. So this allows you to stay based in the foreign country, being paid by the foreign entity, but to enter and not have any restriction on what you can do within your employment for the company. I'll just rush through this quickly. There are certain requirements. They have to be related entities, and you have to be employed by the foreign entity for at least a year. I'm going to hand this over now just to Rebecca to finish the last 2 slides here, dealing with seeking both PR in the US and permanent residency, PR in Canada as well.
Rebecca, you're on mute right now.
All right, so I think we'll just keep your screen up while I talk about this. So the reason we wanted to discuss a little bit this process of pursuing dual tracks, many people are interested, many of our clients who are pursuing green cards in the US have been asking us about permanent residency in Canada, what effect that will have on their green card process. And the reason that this has come up as a topic is because of the many proclamations around immigration, because of a certain amount of uncertainty with the current administration, and obviously, you know, the desire to have a backup plan, or perhaps the US is the backup plan, perhaps Canada is more desirable now. You know, there are different reasons why people want this. We're going to be talking, I think, more about this also from the Canadian perspective. I just wanted to talk briefly about this from the perspective of an employer who may be discussing this with an employee moving to Canada, what the process is going to look like if they're also pursuing a US green card. So they're nationals of certain countries, specifically China, India, sometimes the Philippines, depending on what country, what visa category, what green card category, who have very long wait times to actually receive the green card, which means you may be approved for a green card, but you don't actually have it in hand because there's a waiting list for that country. So there are, as I mentioned, clients who are asking us, what if I pursue a process in Canada, a temporary work visa, permanent residency, what effect will that have on my green card? So you cannot maintain a dual permanent residency because either you are a permanent resident of one country or another. Once you get your citizenship in one country, you can pursue permanent residency in another. So that's an important consideration to keep in mind, that if an employee is going to Canada, wants to work part-time, and then intends to pursue their permanent residency in Canada, that may affect their long-term decision-making if they also have a pending green card application in the US, or green card, or in the line for a green card in the US, and may later want to take up that opportunity. So we'll get into the nuts and bolts of this for individuals, I think a little bit more in next week's webinar that we have planned. But just I wanted to bring this up because this is an emerging topic of conversation, especially given the, as Elizabeth mentioned, the current uncertainty around the economic situation in both countries, employment in both countries, and perhaps wanting to be placed briefly in Canada or for a longer period of time in Canada, while also keeping open a US option. And Ari, we'll go to the next slide, please. So as I mentioned, employees who are coming to Canada from the US who hold US green cards may be reluctant to give this up. Many people have waited a long time for their US permanent residency, for their green cards, so they may want to maintain this. You can remain outside the US for fairly long periods of time while maintaining the green card. However, you cannot become a permanent resident of another country. So you cannot become a Canadian permanent resident and maintain this, and they must maintain ties to the US. This also might have tax consequences for an individual who has a green card, still has to pay taxes, but is working full-time in Canada. So that's something that would have to be discussed also with a tax professional. And again, as I mentioned, if you have an employee who wants to pursue Canadian permanent residency, but they are a green card holder, they may eventually face this decision about whether to abandon a green card or abandon the Canadian process. So I bring this up just as a topic that may emerge of conversation as decision-making around moving an employee to Canada or hiring someone who has continued ties to the US or has a desire to continue their ties to the US. It may be a conversation that one should have earlier than later about what the long-term planning could look like as far as flexibility around enabling this person to maintain certain status or the desire to pursue certain status in Canada. And I think with that, we're probably wrapping up our part of the presentation, and we can turn to some Q&A with the little time we have left.
Wonderful. And as Rebecca has said, next week, around the same time, we will be exploring it's the intersection of the permanent residence routes between US and Canada, how to get PR in both countries, and as Rebecca has said, what to do if you have permanent residence in one country and you're thinking about getting permanent residence in another country. So that's going to be at 5:30 on next Wednesday as well. And so do we have questions from the question and answer that, Zia,
So we do have a couple questions.
Yeah.
First, and this is for both you, Elizabeth, and for Ari, you both mentioned that there are travel exceptions for immediate family members of citizens with permanent residence. Is there a specific definition to family member or immediate family member?
Ari, do you want to go first?
Sure. So the U.S. Immediate family member is defined as spouse, parent, and child under, I think it's 18, 21. That's defined as the immediate relative for the purposes of the U.S. government.
Okay. So in Canada, the travel restrictions for the immediate family is very much defined as it's beyond what normally is defined as the immediate family, which is the dependent child and the spouse or common law partner. So here's the definition. The spouse or common law partner, the dependent child of a dependent child, the parent or step-parent, and the guardian or tutor. Now, the tutor is not someone who's just a tutor. I think it's more in terms of a guardian. So that's essentially the definition of the immediate family.
Wow, that's quite expensive.
It's much more expansive than the US. We do not have common law marriage,
No.
but I will say, or recognized by the states, unlike in Canada, but I will say that we have heard that at least in the past few months, and Elizabeth has informed us that this has changed, that there's been some problems with recognition of immediate family members being admitted to Canada. We haven't seen any of that in the US. Generally speaking, if you show up with your wife and child under 21, if you have proof of that relationship, they will be, and you are a US citizen or green card holder, your family members will be admitted as well. I'd say that it may get a little dicier when you're not with the family member who's entering, but if you have the proper documentation, you should get it.
Yeah, so we did have some issues before where the officer said, well, even if you're joining your immediate family member, it's still discretionary and non-optional, so you can't stay. Now there's been a policy update really in that if your immediate family in Canada is Canadian or permanent residents, and you are going to stay in Canada, I think is it 15 days or
15.
15, right? Then you are automatically deemed to be purposes non-discretionary, non-optional, so you can enter Canada. If it is less than that, you still have to show that it's non-discretionary, non-optional. And if your family member is a foreign national who is in Canada, you still have to get that letter, and you still have to show that it's non-optional, non-discretionary as well.
We did get a question on the US side if there's been any changes or delays to the Department of Labor PERM process. This is a process, this is a green card process, an employment-based green card process by which an employer sponsors an employee who may or may not already be working for the company for a green card. And the first step goes through the Department of Labor. So far, in fact, there have been no proclamations in relation to this. There have been no substantive changes. There's been no overall processing announcements. And in fact, the processing times that we have seen have been somewhat shorter, possibly because there are fewer employers filing new submissions with the Department of Labor because of issues like furloughs and layoffs, etc. So there have been no changes. We don't anticipate any changes. It may actually be a better time to file in a certain way, though we may start getting some pushback on that because you do have to show that there were no US workers who could perform in the offered position. And we may start seeing that challenged a little bit as depending on how the economic situation develops and what the unemployment numbers are like, as we have seen sometimes in past recessions. So this may be the better time to submit a PERM than maybe a few months down the road.
Elizabeth, a question for the Canadian side. Are there any specific type of work permits that are not being processed right now, or is IRCC still accepting all types of applications?
So it really depends on if it's inside Canada or if it's outside of Canada. Inside Canada, they are processing all the work permit applications. There may be a hold because you can't get biometrics, etc. But if you can, they are processing them. Outside of Canada, it's another matter. Oftentimes, what we are seeing with various visa posts is they are saying that they don't want to process applications where the workers are not deemed to be critical to come to Canada. So it's another layer, it seems. So there may be you may expect longer processing times for outside Canada, which is unfortunate because right now a lot of workers are depending on the visa post because they can't apply at the port of entry. They can't just fly to Canada and apply there. We have had some situations where we've flown them through the US because the US doesn't have the travel ban for a lot of the world like Canada does for everything, and then have them fly to Canada and then they can apply for the port of entry that way.
We also have no quarantine. Ari, we got a question about I-140 processing times, which I typed an answer to, but I'll let you also if there's any delays in I-140 processing times.
It depends on the visa type specifically, and the answer is reportedly we're not seeing any substantial delays beyond what was there previously. However, I think in practicality, especially with the coming possible furlough, we will start seeing even greater delays. There's always been inconsistent processing for the I-140s. I think Rebecca can attest to this, that we've gotten applications back that should have taken a year in 31 days, in 2 months. So, you know, we don't know how that's playing out. Is that because there's 60% fewer applications in the pipeline than there were historically? I think when President Trump was elected, it created a mass rush, which threw off the normal progression or the normal number of applications being submitted. At the same time, premium processing has been reinstated, and a number of the I-140s are subject or can take advantage of that premium processing. So we would always suggest that if possible, if you are available for premium processing, you should take premium processing. There's no reason not to, with a number of very few exceptions to that. At the same time, as I said, there are some categories that are not available for premium processing.
So we got a question about a Canadian submitting an I-45 while the I-140 is being adjudicated, and this being a category. I apologize to this person who's asking for it. I'm not sure what they mean by an I-140 for an H-1B for a Canadian. I'm assuming that means that a perm has been done. So I assume
an EB2.
Yeah, I assume if you're talking about I-140 from an H-1B that it's with a perm.
Yeah.
If not, this may be something that we may have to have a more detail. Okay, yes, the perm has been done. Okay, so so can the Canadian submit an I-45 while I-140 has been adjudicated? Have we seen cases where an I-140 is not being approved during the pandemic? I can let you answer that too, but I think briefly the answer is no. And will the filing fee be lost if the I-140 is not approved?
Yes. So that's the that's why in this specific category you can premium process, and so it's a choice. Do you want to take your chances of losing the $1,225 fee to file? If you have relatives, you might want to, you know, they may want to file as well with you. It's another $1,225 for your spouse and $700 per child, or paying $1,440, getting a defined answer from the U.S. government within 15 days, and then not having to worry. Just to answer your question of have we seen them being denied, in no greater amount than usual. So we're not seeing more I-140s being denied just because of COVID-19. I think we're seeing the adjudication rates to be roughly the same. I haven't seen my colleagues mention anything about an increase in denials for no reason, or even an increase of areas or reasons for denial as of late.
I would say that even our approvals have gotten somewhat faster, even with regular processing, because again, I think we have been seeing a decrease in number of petitions filed because of the economic situation here. So if you have the opportunity to file it, it's probably the right time, especially because, as Ari and I mentioned, there may be furloughs. This may affect things. If you have the opportunity to premium process now, we don't know if they will stop the premium processing, the expedited processing again, like they did for about 3 months. So this may be the time, if you are considering doing it, to submit, even though it's an extra fee, you have the certainty. There's no restriction on filing an I-45 simultaneously, whether for Canadians or not, for most categories, most I-140 categories, including EB2 or EB3. So that's somewhat a personal decision, a financial decision, a business decision. I think that's all we have.
Well, guys, thank you so much. We're out of time today, but we'll continue on for the next series, talking about permanent residence next week at 5:30. We'll be posting that on the emails that you'll receive as well, and for the link to register for that. Okay, thank you guys so much. Have a lovely evening, everyone.
Thank you, Elizabeth. Have a great day.
Bye.